My name's Lewis O'Brien. Over the past 25 years, I've helped clients, friends, and family buy and sell thousands of homes. In these 5-minute guides, I'm going to cover a series of topics that I think all home buyers should be aware of. However, unfortunately, too many home buyers don't know that they need to know these things or don't know who to ask. So let's get on with it. In simple terms, nomination is the process whereby the rights of a purchaser under a contract are transferred to another party who then settles the contract so that the title ends up in the nominee's name. This might happen for a number of reasons. For example, your spouse or partner may not be able to attend an auction, or you may decide that you want to transfer the title into a trust or company structure before settlement. We're fortunate in Victoria that the process is relatively simple. You might even say child's play. However, there are a number of things to be careful of, and that's what we're going to talk about in this video. Most contracts in Victoria will include a general condition to the effect that you can nominate. Something like General Condition 18, which is appearing on your screen at the moment, is relatively standard. However, you do need to be a little careful to make sure that it hasn't been changed. One source of changes is the special conditions. It's increasingly common to see special conditions that seek to restrict in different ways and impose costs on your right to nominate. For example, off-the-plan contracts often don't allow you to nominate prior to settlement, and increasingly there are fees and charges imposed by the vendor's conveyancer. Bottom line is, you need to check the special conditions to make sure that you haven't been robbed of the rights you might have thought you had under the general conditions. The good news is that in Victoria, it's reasonably easy to nominate in favour of a company or a trust structure. That structure doesn't have to have existed before the contract was signed, and we don't see some of the other complex rules from other states. I guess the bad news is that if you're looking to nominate in favour of a trust or structure, often the vendor will require a personal guarantee. It is critical when we're dealing with nomination to get it right from a stamp duty perspective. Getting it wrong may mean that you end up paying double stamp duty, which is a horrendously expensive mistake. In Victoria, in cases where you nominated a profit or nominate where land development, including preparation of plans and permits, has occurred, you may have a double stamp duty problem or have a risk, and at that point it's best to get some specific advice. The process of actually nominating is very simple. Your solicitor or conveyancer will prepare a simple one-page form that you can sign and send to the other side. Your solicitor or conveyancer should then take care of the State Revenue Office and other sort of behind-the-scene paperwork for you with a minimum of fuss. An important point to always remain aware of when nominating is that the original purchaser, even after the nomination has occurred, will effectively remain as a guarantor. That means if the nominee doesn't settle, the original purchaser who signed the contract will be liable in the case of default. So hopefully you now have an idea of how simple nomination can be in Victoria, but also the potential pitfalls and traps to be aware of. Naturally, if you're unsure of how to proceed or unsure about potential implications, you should always seek professional advice. And Lewis O'Brien and Associates have been helping purchasers with nomination and a range of other issues for more than 20 years. I hope you've enjoyed this video and got some value from it. If you have, then I'd encourage you to share it with a friend, like the video and subscribe to the YouTube channel, or subscribe to our newsletter at lewisobrien.com.au. We do intend to create a series of videos, but your feedback and suggestions will be invaluable.